following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the latest developments to law relating to the use and regulation of the ever-evolving technology being utilized across the island. How have legal standards been altered along with the rapidly changing technological environment in the country? A very good evening and thank you for taking the time to join us tonight on another episode of Law, Land and Liberty, where we bring to you key legal subjects and break it down for the layman. Tonight's topic is something that greatly affects each and every one of us that's watching tonight, and that's on artificial intelligence and information and technology. Of course, on a day-to-day basis, we all interact with technology and we all have seen the rise of AI in our public and personal spheres, as well as when it comes to a global scale. So to actually make sense of the rapid changes and also how the law plays into the protection of a person's rights when it comes to handling AI and also the data that is being processed by AI, we have someone that is a very well-equipped individual to speak to us here tonight, and that is Dr. Sunil Abeyaratne. Doctor, thank you very much for taking the time to come down to our studios to explain these concepts to our viewers here tonight. A little bit of an introduction into Doctor. He is the chairman of the Communication, Data Protection and Technology Committee of Law Asia. He's the chairman of the ICT Law Committee of the Bar Association of Sri Lanka, and also a pivotal key member of the ICT Lawyers Guild of Sri Lanka that's hoping to make change when it comes to IT practices in Sri Lanka, especially in relation to AI as well. But before we get into the topic, here's a little bit of a breakdown of how we hope to approach this discussion here tonight. First, we'll be talking a little bit about e-commerce and when it comes to e-transactions and how AI plays a part in that. And moving on, we'll be talking about the most essential aspects, which is cybersecurity and personal data protection. And finally, we'll be delving just a little bit on the online safety bill and how we expect it to change moving forwards with the implications of AI. All right, well, without any further ado, let's get right into this discussion. Might I add, Dr. Sunil is also the former secretary of the Bar Association of Sri Lanka. So all notches posted. We have quite the packed discussion to get to, Doctor. I believe you are, if not one of, if not the most qualified individual to speak about this area, especially with how fast it is evolving and developing. Doctor, before we get into the specifics when it comes to AI, I think we'd have to talk about something that everybody has seen a rise of over the past few years, not just recently, but in the span of decades, which is on e-commerce. Doctor, when it comes to the growth of e-commerce in Sri Lanka, how exactly have we seen legislatures that are in Sri Lanka evolve along with it?
Anuradhi, we must understand what is this revolution. When you carry commercial activities, the medium of communication has been changed now. Earlier we used papers, pencils, and that is how we carried our transactions and communication. Now we use the electronic medium at the moment. When we use this medium, we must understand the nature and behavior of this medium. Then we must know, because when you look at ordinary, normal commercial activities, commercial transactions, there are some principles and laws are involved in that. Now take example, when you take law of contracts, there are some principles, offer and offer theory, invitation to treat, we call the supermarket, inside supermarket when you display goods, we say this invitation to treat, then misrepresentation, how you are misled by vendors in the market, then illegal contracts are involved in that. We call sometimes exemption clauses because you are not liable, so if something happens. Likewise, there are a number of principles. Now, we must find out whether these traditional principles can be applied for electronic transactions as well. This is the challenge before lawyers, judges, and the ordinary citizen. Now, when you take electronic commerce, some countries, they have already enacted piece of legislation relevant to e-commerce. Take example in European Union countries based on e-commerce directive. Directive in the sense they give these directions, provisions relevant to all their member countries. Based on that, they have introduced their own individual e-commerce act relevant to their country. But within that framework, following EU countries, United States also accepted basic principles comes under this e-commerce. Then Australia, New Zealand, other developed countries and developing countries also already accepted these basic principles. Then United Nations Trade Commission came forward and introduced model law. We call this first model law as UNCITRAL Model Law on Electronic Commerce in 1995. They brought some amendment to that in 1996, then 1999. Later they realized there is not much recognition of this electronic commerce model law for electronic signatures. What they did was they introduced another model law. We call this model law as UNCITRAL Model Law on Electronic Signatures. Based on these two model laws, Sri Lanka enacted Electronic Transactions Act in 2006. Now when you look at provisions under Electronic Transactions Act, we have the basic legal framework to deal with electronic communication. Question arises whether our act is e-commerce act or e-transactions act. There's lots of controversy over this issue, and some cases decided before Civil Appellate High Court. Unfortunately, it need go to the higher forum. There are not much authorities. So then other countries also started to practice this e-commerce concept. Later they found there are some loopholes, some grey areas are there. When you take model law, there is no compulsion imposed to the member countries of UN, United Nations. Then what United Nations, what they did was they introduced a convention. We call this convention as UN Convention on International Electronic Contracts. This is a short form. We are fortunate enough, because we are fortunate citizens and country. Sri Lanka and Singapore from Asia, these are the only two countries ratified this convention. So based on that, this is an international obligation now, after ratifying this convention. We brought an amendment to this E-Transactions Act by Act number 25 of 2017. So then we have brought various amendments, especially when you look at Section 7. Section 7 explains what is the electronic signature. So likewise, we have brought some amendment. Anuradhi, when there is an agreement, that agreement must be enforceable agreement. Section 18 of Prevention of Fraud Ordinance says, if the particular material, instrument is in writing, and if there is an electronic authentication, that means signature, we call that particular instrument as enforceable agreement. It doesn't mean that you can't build up agreement verbally or by conduct. You can. But when it's in writing and when there's an authentication, it's directly enforceable instrument. Question is, how to fulfill this requirement when this instrument is in electronic form? This is what UNCITRAL Model Law, UN Convention, and as a result of that, our E-Transactions Act did. When you take section 4, 5 and 6 of E-Transactions Act, we have fulfilled that first requirement come under section 18 of Prevention of Fraud Ordinance. If any act or any law of the country says to satisfy certain matters, say some argument or whatever it is, to take example under Land Development Ordinance. If the government authority says the person who is occupying the land has no right to stay in that premises, then there are some options to that person. He can satisfy that he has legally valid permit or permission. Now, how to produce this? All right, in 1940s and 1930s, authorities issued hard copies. But sometimes you can't use these hard copies at the moment. So what they do is, their children, they are familiar to mobile phone, computers. What they do is they get a scan copy or they get a snapshot. What is the validity of that document? When you look at section 4 and 5, you can produce that electronic material. So what is the second requirement? Second requirement is authentication. Now, if it is in electronic form, that's electronic signature or digital signature, there must be a recognition for that signature. Otherwise, you can't fulfill the second requirement under Section 18 of Prevention of Fraud on Email. This is what we have done, introducing Section 7 under Electronic Transactions Act. What is the method? There is no particular method specified under this act. You have to consider all the circumstances and the requirement of this particular document and why they are carrying this online transaction. Considering everything, you have to satisfy, if there's a dispute arises, you have to satisfy reasonable method was introduced for this transaction. Now, Anuradhi, if you get a SMS, how do you know that it comes from a particular person? Because you will get sender's mobile phone number. It's also a signature. For your transaction, it is enough. When you send email, there is no signature. That you will get the email address. But anyway, you are using the same methods to carry some very serious transaction. So maybe $1 trillion US transaction. Or sometimes you have to send your one of the very important education certificate to another place. Then you don't send this as an attachment through these mechanisms. Then you have to take additional precautions. So that is why we need electronic signatures or digital signature. So that depends on your transaction. This is what Section 7 of E-Transaction Act says. When you look at these transactions, we can say we have satisfactory legal framework to carry online or electronic transactions.
But Doctor, when considering, you just mentioned that we have to consider the scale and the importance of what we are dealing in, and also then make sure that the authentication factors are relevant to such an activity. Do you believe that our legislature as it stands now has enough of a protection when it comes to consumers and also people that partake in such transfers and transactions?
Basically, our legal frame is strong enough to provide this facility. On the other hand, that third-party authentication is there. It's like attesting deeds. Why we get down the professional service of notary public? Because these are immovable transactions are there. We have limited resources. Land is limited resources of a country. So that's why we need third-party authentication. Here, when you placed digital signature or electronic signature, your computer also you can program up to a certain extent. But if you can get third-party independent authentication, it will be a very strong authentication for your transaction. Now, service providers are defined under our E-Transactions Act. But the issue in Sri Lanka is there is no criminal liability or civil liability on this service provider. They have only contractual liability. There is one matter we have in future, we have to think about this aspect. Other countries, they are subject to criminal liability and civil liability as well. Here you have only contractual liability. Other than that, as I explained to you earlier, we have drafted this act based on ancestral model law. So ancestral model law is the piece of legislation introduced to most of the UN countries. When you look at the other e-commerce acts or some e-transactions acts in the world, there are similarities. Now, after ratifying UN convention, take Singapore. Singapore has a similar e-transactions act like Sri Lanka. But what's the difference? They are carrying their online transactions successfully. Singapore has become that e-commerce hub also in the region,
exactly,
next to India. So what is the reason? Now we have to look into this matter because we don't have enough regulations. Now, a legislature can introduce acts. Through acts, we can give only legal framework. To strengthen this legal framework, you must introduce regulations to regularize these provisions. This is what we are lacking at the moment.
We do have to get into the regulatory aspect as well, Doctor, when it comes to artificial intelligence and also personal data protection and the cybersecurity climate in general. And there's a lot for us to unpack when it comes to recent developments and the expected legislative changes we can see moving forward in the current regime as well. But before we get into any of those specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this. Welcome back to Law, Land and Liberty. We're in conversation with Dr. Sunil Abeyaratne. Doctor, thank you very much for the previous segment. It is a good foundational understanding when it comes to e-transactions and e-commerce. We just left off on what I believe is the meat of this entire topic, which is the regulations aspect. Before we get into what needs to change in the regulation sphere, I think we need to talk about the cybersecurity space as well, not just when it comes to commercial transactions, but just cybersecurity in general. Doctor, could you tell us what the climate is like right now when it comes to cybersecurity in Sri Lanka? Are we seeing progressive change, or is it a precarious landscape?
Anurad, if you put this question to computer engineer, he might give different answer.
Definitely.
When you put this question to a person who is involved in legal profession or this justice system mechanism, what we can see is there are three pillars as far as cybersecurity is concerned. One is confidentiality, other one is integrity, and the retrievability or availability. Now, if you receive a letter from another person, how we are going to trust on that letter? Because we are confident. You can understand his or her handwriting signature. You are familiar with that. That's why you are confident. Because you have to apply the same thing here. And if you received a letter in open envelope, what is your attitude?
Of course,
you have lost your confidence. So that's why integrity. Integrity must be there, starting point up to the ending point. And the retrievability. You may have a thesis or any good assignment or whatever it is inside your computer. If you, the day you have to submit it, if you can't open that document, what's the point in having that document? So these are retrievability. When you have this confidentiality, integrity and retrievability, we call this cybersecurity there. This is what you have to provide for electronic authentication. This is what Section 7 also says. Placing normal signature, that means email address or mobile number, or maybe some electronic signature. The biometrics also come under that category. And digital signatures satisfy this cybersecurity. Sometimes this is the issue in our country. Sometimes authorities, because I have advised a number of governments and authorities, sometimes people who are involved in IT sector, sometimes they are in the impression that you can provide everything through technology as far as cybersecurity is concerned. But there is no standard cybersecurity in the world. It's a must, it's mandatory. You must provide legal definition and legal impact on the cybersecurity. Otherwise, people are not safe. If there is no proper law to deal with cybersecurity, if there are no regulations to monitor the cybersecurity, you can't expect 100% secured method. So this is the secret. Actually, you can't say secret. This is the
open secret.
Open secret. Now, if we follow this, then people will get technical support in addition to that legal support to maintain cybersecurity. If there's a violation, then there's a remedy. Now take example. If some top class, some service providers provide some security as cybersecurity. Now what is the guarantee that it is 100% secure now, considering the development of technology? So there must be legal frame to protect that. So this is what UNCITRAL model laws and UN Convention on International Electronic Electronic Transaction Convention, we have ratified. So ratified means we have under this international obligation now. There is no escape. So that this is time to implement that.
Enactment.
Enactment in the sense, now we have to bring some regulations and strength. Not only that, Anuradhi, I explained you earlier. At the moment, there is no criminal or civil obligation, no liability on service provider. This is the time to introduce that. And if we work on this area, now this is the era of, we call this a digital economy. If we go ahead with a digital economy, keep in mind that there is a legal framework, basic legal framework is available in the country, then we can achieve this target. If we forget this, the legal framework can go ahead, you can go up to a certain extent. All the other countries, developed countries and most of the developing countries, they achieve this goal, strengthening legal framework as well.
There has to be a scaffolding in order to ensure that the structure doesn't completely collapse once there's an unencountered or unforeseen circumstances as well.
In this country, this is the trend. They demarcate their boundaries. Even ministry that subjects also. This is pure technology, pure law. Law comes under Ministry of Justice. The technology comes under different ministry. No, there must be proper interaction. Especially ICT sector is concerned.
Of course, ICT is integrated into every aspect of our lives at this point.
Now take, we put a question AI. Now take different fields, take agriculture. When you say agriculture, one might think that what is the legal impact on agriculture and what is the involvement of AI agriculture. So there is a direct involvement there. Now you must be in a position as a civilized country who applied and used technology. We must be in a position to find out what is the exact fertilizer requirement in 2030 or to 2028. We have data. Then there's a process mechanism is there. So if we can predict the exact requirement considering the climate and vegetation, everything, then without wasting money, without wasting fertilizer, when we import fertilizer, then whose money? This is our citizens' money, this is taxpayers' money. So then you can save it. You can put that money to other areas. Even the fisheries industry also same. You can't just send trawlers to sea. You should know what are the exact catchment area. So considering that, you must be in a position to send these boats and trawlers to the sea. Through AI you can do it. Then take energy sector. We have lots of issues couple of years back. No? If we applied AI, then you are in a position to predict the fuel requirement. If we get down investors to this country, you must be in a position to find out what is the exact energy requirement in another 3 years, 4 years. Say if we get down 100 investors, if they put up factories there, do we have enough energy? Then if we give energy to these investors, what is happening to our domestic users? So there is no such research we have carried. So these are I'm giving some simple example.
The implementation.
Exactly, the education. If you can, applying AI, if you can monitor the performance of a child from a kindergarten level up to O level, then that person will be a very useful person to the country. Everyone has some unique skills. So it is the duty of the education is to cut and polish, so reshape their skills. So you can apply this AI.
The implementation aspect of AI is very much underrepresented in Sri Lanka, but more so than, I believe implementation is a few steps ahead of where we are currently, which is when it comes to adequate protection relating to AI and knowledge relating to AI as well, because even to implement such advanced algorithms, we as a people need to understand how exactly AI is implemented and how it is enacted in our spheres, and to really know what AI is doing in our lives. When it comes to the protections aspect, Doctor, I'd like to just go a little bit further back in the discussion before we move forward with the AI topic, which is on the liability aspect. You mentioned, Doctor, that there's very lax regulations relating to service providers and their liabilities towards the people. Are we working on that in any sense when it comes to the legal aspects of it? Do we see any sort of changes to be brought so that people can have more added protections, or do we have enough as a basic necessity before we move forward?
Under my chairmanship a couple of years back, we had the e-commerce review committee appointed by the Ministry of Justice. We have already given our comprehensive report with all these recommendations. So these are the issues we discussed in that report. Now we come to the implementation part. We have done our duty. Government may be changed, but it is up to the authorities to go through our recommendations and consider the implementation. Now, answering your question, this is like a chain, it's interconnected chain. Now take one example. We are talking about e-commerce and e-transactions. Then what is the consumer protection? Consumer protection is also part of it. Are we ready to carry real online transactions? What is your safety? If you get something through, say, that online platform, so what is the guarantee that you will receive the same item you expected before you order? If you receive goods or services that you are not satisfied with that, then what is the return policy in Sri Lanka? How do you get your money back? In European Union countries, especially even in Australia and the United States, developed countries, because I am giving this example, you can easily go through websites, you will come to know how they are working. They have distance selling laws. Online distance selling laws are there. When the consumer or customer made the payment, then and there you will make the payment using your cards. So there is no way to stop your payment. But for the next 7 days sometimes, so if it's a perishable item for next 24 or 48 hours, this money will not be the money of the vendor. It will be a trust money. The vendor will keep this money on behalf of the customer or consumer for next 7 days. He can't spend. If the customer is not satisfied with goods or services received, then he is in a position to return it. Because their consumer protection is very powerful. Then it's a liability of the vendor or seller to return that money. Anyway, that we are happy to announce there's a gazette notification came last year to Consumer Affairs Authority Act in Sri Lanka. Up to a certain extent, we have given that protection. But anyway, it is high time to reshape the sections and provisions under Consumer Affairs Authority to fit into online transactions. Without any delay, we have to do it.
To better tailor to
Yes.
the rapidly evolving landscape of online transactions, just how quickly and how effortless and seamless it has been made, we need to make sure that the protections are also awarded alongside it. Doctor, you mentioned something relating to data protection as well. I think I'd like to delve a little bit into that aspect. When it comes to personal data protection, now we've seen the Personal Data Protection Act and relevant legislature being enacted, but we haven't really seen much noise or updates relating to how it's going to evolve in order to better protect us from the changing technological environment. Are we seeing change in that aspect, Doctor?
We can see some development. Under the UNI, we have some privacy. It's your right, it's my right as well. But geographically, country to country and period to period, time period to time period, these privacy policies are changing. There is no permanent privacy policies. But anyway, you and I, we have our basic privacy. Considering this concept, other countries, especially developed countries, including European Union countries, initially they introduced a data protection directive. So in the meantime, Hong Kong and New Zealand and Australia, they also introduced very powerful data protection law. There are two types of data. They call the sensitive data and normal data. This protection provides for sensitive data. This is what we call as personal data in Sri Lanka. We have a brand new Act number 9 of 2022, Personal Data Protection Act. It will be fully operated from next year. There we are, at the moment we are at this transit period. Now when you take data protection, when you collect, we call this collector as data collector. Data collectors must follow 7 principles. Because what happened was earlier data protection directive was there, then European Union countries realized these directives are not too much powerful. What they did was they introduced general data protection regulation. We call this as GDPR. Why this GDPR relevant to us? Based on 7 principles comes under GDPR, we also drafted our act. That's why these 7 principles are important. What are these 7 principles? When a data collector collects data from the person, we call that person as data subject. Now if I get data from you, Anuradhi, you are data subject, I am data collector. For the purpose of processing. What is processing? The interpretation is there. In any activity, processing in the sense collecting, deleting, adding, everything comes under this processing. For purpose of the processing, if I collect data as a data collector, there must be a transparency must be there. It must be fair, because fair in the sense, I can't get your some personal data not relevant to my requirement. I can't take all your personal data. Say if it's a job interview, now this is a trend in European Union, you can't ask who's your father. What they say is, mother is there, child is there, that's enough. That is true. What's the discrimination in a country like Sri Lanka? Saying that illegitimate child, legitimate child. So now this is the trend. Even some countries are there, in China, South Korea, even in Japan, you can't ask a question from a person, what is your religion? They don't answer. They say, I don't have religion, but they have religion, but they don't tell that, because these are very personal issues. Then if you collect this data, it must be relevant to your purpose of collection of this personal data. If you collected, as a data collector, if you collected additional data, it's a duty of the data collector to delete or remove. Then the third is, it is a duty of the data collector to return this additional data. The next is, we call this a data storage. That means, so if you have an agreement relevant to a particular period, during that period, if the data collector collects this personal data from you, if your agreement is over, say by 31st of December your agreement is over, then 1st of January you will go to another person and with a different and new contract, then I have no right to keep your data after 31st of December. The next is, after collecting this data, it's my duty to provide security. Then the next, it says, if you want, you can withdraw this data, and accountability must be there. What is happening to your data? You are entitled, at any time you can say, no, I am not happy with your database or collection, please delete that or return data. Likewise, there are 7 principles. When you go through our Personal Data Protection Act, you can find these 7 principles. The following 7 principles, it is easy to understand the provisions under our Act. We have some schedules. The different schedules provide different type of consent. Anyway, one thing we must keep in mind, whistleblowers. That means for criminal investigation purposes, there is no condition, police or other investigators, for criminal matters. Under criminal justice mechanism, they can collect personal data without any condition. So this is the structure of our law.
Apart from criminal investigation purposes, we do have somewhat of a, well, when it comes to the actual act in itself and the principles that have been enshrined in this act, we see that there is a very hopeful outlook when it comes to the accountability aspect, especially when it comes to service providers and big entities that are responsible and in charge of collecting data of numerous individuals across the island.
So that is why you have to nominate a data officer, data in charge person. Because if a person asks the personal data from a particular institution, then if there's a controversy, then data officer
there's
has
a
to
representative.
Exactly. If you are not satisfied, that you can appeal to data commission, like that. We must keep in mind, data protection law and right to information are 2 different sides of same coin. As a democratic society, you and I, we have a right to know what is happening in society. This also we must not forget. We have to balance these 2 acts. This is what any democratic country will.
Very important point there. We need to be in the know in order to ensure that our rights are not violated, and in order to ensure that we are given the awarded protections in an adequate manner, and we are not defenseless against any malicious intent from any entity. We have to talk about the changes that we can expect moving forward as well, and also the online safety bill, which is a very controversial aspect of law in the current moment. Before we get into any of the specifics relating to the online safety bill, and also on the awarded protections and the improvements that we can see moving forward with the current regime as well, let's take a very short commercial break. Well, Law and Liberty will be right back with the final segment. Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Dr. Sunil Abeyaratne. Doctor, thank you very much once again. We're in our final segment. We don't have much time, but it's a topic that is quite controversial recently with its amendments and its changes. Could you please explain to us, Doctor, the online safety bill, its current position at the moment, is it enough for the Sri Lankan people?
Anuradhi, initially that we use computers and word processors. So thereafter, internet became very popular. So that's why initially we also introduced Computer Crime Act 2007. based on the provisions under Computer Misuse Act 1990 in the United Kingdom. So thereafter, there's a requirement to bring new set of offences as far as the development of cyberspace is concerned. This is what other countries also have done. There's controversy over this act, not act, it's a bill, online safety bill was nomination of commissioners to handle provisions under this act. This is what happened. Otherwise, offences are same. On the other hand, when you look at some offences under Online Safety Act, without bringing new act, you would have brought an amendment to existing Computer Crime Act. Then some provisions are already there under the Penal Code. Because under the Penal Code, there is no differentiate between online or offline offences. It's common. Take example, impersonation. So you can apply impersonation online and offline both. If you feel that that provision is not enough, we would have raised the sentencing mechanism. That means to increase the fine or sentence. But anyway, following other countries, we also brought this Online Safety Act. So at the moment, there are no commissioners once again appointed to the Online Safety Act. So all this in the transit situation at the moment. With this, what we can feel is now earlier there was a criminal defamation offence called criminal defamation under Penal Code. So some political reasons in 2002 we removed this provision from the Penal Code. At the time of removing, there was no much activities on Facebook and the social media. So later governments also realized, but they couldn't reintroduce this act due to various other reasons. But anyway, the same offence was introduced under Online Safety Act. But we can see there's a development as far as that innocent victims are concerned. But anyway, one hand, freedom of expression must be protected. This is a fundamental right guaranteed under our Constitution. On the other hand, we have to look into the victims as well. Once again, we have to balance this situation. If you implement this act with a genuine intention, there won't be any issue. That is why we had the doubt earlier. So that we also filed through our ICT Lawyers Guild also filed a case against Online Safety Bill because of that reason. Earlier the nomination came through the President of the country. Removal also came from the President of the country. Then this is not the way to carry matters under criminal justice mechanism, because police department is out under this act. So these are the issues under this act. So considering our socio-economic, political and cultural reasons, because this is also one of the Asian countries, what we can do is we can hand over criminal investigation part to police department. Then there is a question arise, whether police department is competent enough to carry investigation under this act. Then there are some other mechanisms. This is what Indian government did. So they can set up separate unit under police department. But anyway, that there must be a responsible mechanism. So this
we
is
already have a law enforcing entity. They should technically be playing a part in the enforcement in this aspect as well.
Yes. So other than that, we have at the moment we have Computer Crime Act. Now we have Online Safety Act. It doesn't mean that if you ask how many offences I could commit using computers and network, I can't answer. Maybe millions or trillions. Why we have only these two acts? And the Payment Device Fraud Act is also there. But when you look at offences specified under these three acts, these are unique offences. We can't find parallel same or offences under the Penal Code or any other statute. That is why that we brought these offences under these specific acts. So when you look at criminal justice mechanism in this country as far as computer technology is concerned, we have basic legal framework.
We have some form of footing in order to go ahead.
But the question is enforcement.
Exactly. I think that's where I want to direct our attention to as well, because we're nearing the end of this discussion. Doctor, one of the most significant areas of our conversation is about to occur when it comes to enforcement and when it comes to what we can expect when it comes to increased regulations moving forward. What can we expect as the general public? Will we be able to see legal entities being able to actually commit to this legislature? Will the current government make their proposed changes and actually stick to it?
Anurag, the ignorance of the law is not an excuse. That's the general concept. But how to apply this without educating the citizens? The legal education is very important in the country. Legal education, it doesn't mean that it is only for lawyers and judges. Even general public must get this at least basic legal education. What we can do is, now the ICT is a subject for all level, ordinary level students. So from the grade 7, grade 8, grade 10, we can introduce, step by step, we can introduce these offences to this subject. Then school children will come to know if they misuse computers and network, so it's an offence, it may be an offence, so there are consequences. So at the moment, the problem is most of the people who are involved in ICT sector, even, they don't know if they misused or something happened, it comes under criminal justice mechanism or not. So this is very important. In the meantime, law enforcement bodies, police department, bribery department, because they can use this even artificial intelligence, if they come to that level, they can apply, they can use AI for investigation, successful investigation. So this is the high time to apply this. So if it is so, then they must know what is the legal impact on this technology. In the meantime, we have to, at the moment, we are training our lawyers and judges. Even our legal, this very slow mechanism is there at the moment. This is not the fault of our ICT Law Committee of the Bar Association, no, because we are giving their education. Sometimes most of the lawyers also, they like to stick into normal subjects because this is a technology-based law. Anyway, in another 4 or 5 years, because at the moment, digitization of court mechanism is happening at the moment. After 4 or 5 years, sometimes if we don't know how to use computer network, sometimes we can't practice before courts. It will come to that level. Step by step, we are going to that era. So then the legal education for lawyers is also very important. As a responsible government, they have to think about this matter very seriously. So they must have some program for it. Otherwise, only the Bar Association or that people who are involved in individual, because we can do it, but it will take at least 10-15 years. But we can't wait until something happens. It's high time to involve. They all must involve in that, develop the mechanism. Legal impact on ICT and legal impact on AI is very, very important to the future of this country.
I think that's unfortunately one of the most important points that we can take from this discussion. As we are nearing its end, we really need to ensure that we know the significance of education and being in the know relating to these rapidly evolving technological concepts that we see introduced into the island. It's not just the legal practitioners, but also the general public. There is a share of knowledge that needs to be circulated in order to ensure that best practices have been instilled in both public and private circles when it comes to technology, because there's no avoiding it, of course.
So we must thank your channel, because this is what you are doing, this national duty. Even the media has to play a very vital role. This role plays very, very important to the citizens of this country.
All right. Thank you very much for taking the time, Doctor, to speak to us here today. Thanks again.
Thank you very much for inviting me.
All right. Well, we leave you tonight with the words of Bill Gates. The intersection of law, politics, and technology is going to force a lot of good thinking. Well, that's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Other Derana English. Thank you very much for watching. Have a good night.